All right. Well, good morning, everybody. This is Valentine's Day, February 14th, and we are having a meeting of the House Criminal Law Subcommittee. We have 4 bills on the docket today, but we are going to attempt to start with House Bill 664, which is a bill that just passed out of the Senate cross-file, and it attempts to shield personal information from judges in Maryland. Chris, do we have the judiciary folks with us that we can bring into the room?
I see Chief Justice Fader, and this is Kelly O'Connor.
Hi there.
Hello, everyone.
Was Judge Morrissey going to join us this morning?
He is. Let me give him a call.
Okay. Should we wait for Judge Morrissey before proceeding? All right, let's give it a minute. And just for the our judiciary.
Can I ask you a quick question then while
Yes.
we're waiting? Is there going to be, are we going to wait for the judiciary to come on to discuss the State Bar Association's request to have a person on the study or the task force as part of the bill? Do we need to have
Judges here? If you'd like to wait for Judge Morrissey, or if you'd like to jump into the discussion, we can do that.
I'll tell you that the judiciary views that as a favorable amendment and supports that request. So I don't think you need to wait for anything else from us on that.
Okay. Well, it sounds like we can just dive into the conversation then. And perhaps if Judge Morrissey jumps in while we're into it and wants to weigh in, he can. Colleagues, hopefully you all had a chance to take a look at House Bill 664. There is an amendment request if you look in the file, and perhaps it might be useful for us to start with a refresher from Judge Fader on the basic intention of the bill. We have an amendment request to add MSBA into the task force into the bill. And then third, we have a version of the bill that came out of the Senate. And I guess I would ask whether the judiciary likes that version and can comment on the changes that were made in the Senate before we proceed with the House version. So why don't we start there? Judge Fader, if you want to take it away.
Sure. Thank you. And thank you for your continued attention to this bill. There are 3 different segments of the bill. The first identifies specific types of personally identifiable information that would be protected from disclosure on the internet, both by private and government entities, including home addresses and previously unpublished telephone numbers, but also additional information that could lead somebody to the judicial officers or their family members. The act requires removal of that information from the internet upon request, and if the entity refuses, it allows a lawsuit to compel that to happen. And for private entities, damages. It does carve out information that the individual has previously made public or that it's been made public with the individual's consent, so that's not identified as personally identifiable information. And it also has a carve out for matters of public concern. As I said in front of the full committee, that these things will rarely be matters of public concern, but where they aren't covered, and that's a carve out. Second, the bill does create an address confidentiality program where there are greater concerns, and that would cover private or paper records in addition to information that's on the internet. An individual with legitimate business need could still get access to that information, such as for title research purposes, as an example, as can individuals pursuing a matter of public concern. But in those situations, notice would be provided, so the security risk at least would be known at that point. And third, the bill attempts to create address a different but no less important safety concern by creating a task force to study security issues at individual courthouses. There are specific security issues that are carved out there, and I'd be happy to go into more about what they are. but that's the task force that is proposed, and that's the task force that the MSBA has asked to join, and that we're supportive of them joining. So I don't want to go over what was already tread in the full hearing, but I'm happy to address any questions about any of those areas. Looks like Delegate Kaufman already has his hand up.
Yes, may I go, Mr. Chair?
Yes, go ahead.
Mr. Chief Justice, Your Honor, it's nice to meet you. My question is, can you go into what would constitute a matter of public concern? Because, well, my concern is that somebody who's mental illness or just is a little off, or nutty, could say, well, it's a matter of public concern that I know that this judge lives on, Kaufman Lane or whatever. And so how do we make sure that, public concerns are met, but it's not a Pandora's box where anyone can argue that that knowing their address is a public concern, or knowing where their kids go to school is a public concern? Is it a high threshold? I guess is what I'm asking.
So this is an attempt to accommodate First Amendment concerns and certainly areas where there might be a legitimate concern. One example that was raised in an editorial that was published by the Baltimore Sun was, well, what happens if there's a bribery scheme where a litigant overpays for a judge's house, and the overpayment it would constitute a bribe. So that is a circumstance where one could legitimately say the location of the house that was overpaid for would be relevant to the story, and there's legitimate public interest in that story. I think that these are very, very rare informations where that could come about, but it certainly would not be intended to cover the situation that you raised, which is just an individual who they themselves think it's a matter of public concern, but there's not a way to articulate a legitimate public interest in it. That would not be covered here.
Okay, thank you. And just very briefly, Mr. Chair, if I could just make a comment. Maybe, I'm going to vote for this. It's a very important bill, but maybe the committee ought to consider putting in stuff about what is not a public concern, because I think sometimes people can be very entitled and could use that to spin it and say, well, this is a public concern that I know this or that. So anyway, I've talked long enough. Thank you both. Nice. Thank you, Your Honor. Thank you, Mr. Chair.
Thank you.
Thank you, Delegate Kaufman. And actually, I do want to actually expand upon that question, just so that we're comfortable in the structure of this. So if there is a judicial ethics question of some sort where the shielded information might be relevant, what's the mechanism and who is the arbiter contemplated for how this would actually get resolved?
So I'll first say the first component of the bill deals with information that would be publicly available on the internet. And so that does not shield information that would be available in paper records. So to the extent that there is some concern there, people would be able to go to the paper records and get access to that information. It would, to the extent that somebody wants to actually post that on the internet, there's that would have to be well, the law would give the judicial officer the ability to request removal. And if the answer was no, then they'd have the ability to file a lawsuit that would say that would seek to compel the removal of that. And then there would be a neutral, impartial judge who obviously wouldn't have any interest in that, who would be able to say, no, this is a matter of public concern. It would be litigated in that forum. So that would be the forum in that respect. If you're talking about somebody who's participating in the address confidentiality program, which actually would go to paper records as well, then it would be the custodian of those records. So, for example, if you have land records in a clerk's office and somebody goes and sees that that what you can get without having to go to the counter has a redaction on it that says this information is protected, you need to go to the counter in order to get a copy of it, then it would be going to that custodian, and then you'd have a circumstance like you do with a lot of records, under the PIA, where the custodian of the records would be asked to make a judgment call on that, and of course that could be pursued by litigation as well if they didn't release it. But one of the primary sources of information we're talking about here is, of course, the land records, and we have consulted with both the archives, which runs landrecords.net, and the State Department of Assessments and Taxation, and with title researchers who are all comfortable with this, that where there's a legitimate business need, there will be access to this information. And that's the same process that would be used where, for example, if a reporter is coming looking for that information as well.
Got it. Thank you. And sorry, we'll turn to Delegate Carter in just a second. I'm just taking a spin through the Senate version of this bill. And just to clarify, they did include the MSBA in the task force. It also looks like the public defender and say MSAA is on this amendment, and the chair of the Orphans Court. I can't tell if it looks like these are additions by amendment. So if you could comment on whether I have that right, and whether that's I guess desired, or what the rationale was, that'd be helpful. And the other is, you've struck the committee, or the Senate struck the term person and replaced individual, which I can't tell if there's any significance to that, or if it's just a stylistic change that was made. But again, I guess the question is whether you like the totality of this amendment.
So on the addition of the individuals, I can't remember where it was, but the public defender did specifically ask to be included in this. I think that was only on the Senate side, and that's where they did that. My assumption is that the state's attorney representative was added to provide balance with that request. And I don't know where the request came with respect to the chair of the Orphans Court. We don't object to the inclusion of any of those individuals on the task force. We were looking to make this broadly representative to make sure that everybody who has an interest in it can participate, and those entities all fit that. So there's certainly no objection there. As far as the striking of person to individual, I don't know what the specific motivation was there. Obviously, individual is to be a living person as opposed to a corporation. And that was in which provision?
Senate amendment replaces the term person with individual, from what I can gather.
And they replaced it in one specific provision, I believe.
You are correct. Let's see. 32304. Just this section about publishing, the penalties for publishing the personal information. Right. It changed from a person may not publish to an individual may not publish. Right.
And I do think that person is our preferred term. They were trying to limit that so that I assume that if a corporate entity did it, that that they wouldn't be responsible. That it was limited to an individual. So, I mean, obviously, corporations, corporate entities act through individuals. But if it is a decision of the entity or an act of the entity, then I think person is covers more, and is appropriate to cover more. So that is still our preferred term.
Okay. Delegate Cardin.
Thank you, Mr. Chair. Thank you, Judge Morsi, Judge Fader, for both being here. So first of all, just going back to the individual versus person, this is like back from, I think, law school for me, but I think that a person includes a corporation and an individual a person and a human and a corporation. I think individual also includes a corporation and a human. I think they both do. I agree with you, Judge Fader, that we should make sure it's as comprehensive as possible, because you want to be able to capture corporations as well. I can see, for example, somebody who claims to be a news outlet or some sort of corporate press entity, whether it's legit or illegitimate, trying to hide behind the corporate entity, and you want to make sure you capture that. So whichever is the best, maybe we ought to talk to legal counsel. That would be my first comment. My second comment is that a legitimate business purpose or a public interest are the two reasonable rationales that somebody should be able to have access to certain information that might be shielded. I cannot think of, and maybe you can you gave us an example. I don't think that example actually as far as I'm concerned, didn't hold water as to why there's a legitimate business purpose or a public interest purpose in knowing personal identifying information about either where you live. If there's like a lawsuit against you or a question of ethics, I'm not sure why the public needs to know what the residence was. I mean, your example that you used to live in, that you sold the house, as opposed to just the information that you sold the house. It was an overpayment by substantial amount, by hundreds of thousands of dollars, whatever, but not the actual addresses and personal information. So can you tell us when there's a legitimate business purpose or public interest purpose for knowing your, ability to get to your residence or to your children or to your spouses?
Well, the legitimate business purpose is easier than the matter of public concern, and that's dealing with a title record search. I mean, if you're going to be able to convey good title, a title company needs to be able to have access to that and validate that. So
right, but and I agree when you're dealing with for when you're talking about a sale of property, when you're dealing with business for you, right? But I'm talking about other people not involved in the business. Why should somebody else know about your business transactions?
I can't point you to a good example. I think that a case that there would be exceedingly rare, but we wanted to put forward legislation that would not be subject to challenge on First Amendment grounds. This is an exemption that is in the federal law, and is there for the same reason, to insulate it from challenge on First Amendment grounds. And so whether an exception actually would fall within that, I agree with you that it's not necessarily the case that even if knowing the address is important to uncovering the story, that doesn't mean that it's appropriate thereafter to publish it online. But we wanted to make sure that this was not subject to challenge on those grounds, and whether an exception does actually apply, that would allow that to be a matter of public concern to be to appear on the internet, is something that would have to be worked out on a case-by-case basis going forward.
If I may, Delegate Cardin and Justice Fader, Chief Justice, you've given me something to think about here, and I guess a couple examples come to mind for where we might bump into this kind of situation. The first is if you look at some of the U.S. Supreme Court ethics conversations right now, and there are questions about, whether wealthy benefactors with business before the court were paying for X, Y, and Z property or rent or tuition, as it were, for family members and things of that nature. Certainly that's a rare case, but I think that's one pretty significant national example that's been in the news recently. I think on the edges of it, there are other questions I've seen in recent local cases about, say, loans from people with business before the court to judges in various capacities, a campaign loan or something like that. Anyway, if one were taking a look at these questions, I guess, is the answer, I understand the process as you've outlined it, but is the answer that some of this information is still nevertheless available on paper if a investigative reporter decided to go that route?
Under the first part of this, meaning the part that deals with information on the internet, it's only on the internet, and so that information would still be available in paper. The address confidentiality program, if somebody took advantage of that, the information wouldn't be available on the public side of the desk, if you will, in paper, but would still be available on the other side of the desk for in paper form. And I obviously can't prejudge any specific example of what might be requested to be a matter of public concern, but whatever it is, the exception is intended to apply in that circumstance.
All right. So sorry. And just for the clarity for the judges also, we're not going to vote today, or we're sort of gathering info, and we'll bring this back up next Wednesday. But should we try to move something next week and we have differences of opinion on something like the person versus individual scope in the bill? Is your preference to have your desired form of bill prevail, or to conform to what the Senate has already done?
I'm not sure I understand the implications of the question. I'll say, I mean, we certainly don't object to the bill in the form that the Senate has passed it. Notwithstanding that we would have a preference for the term person. So I don't know if that helps, but and Chief Judge Morrissey unmuted, so maybe he has a contribution.
I think that what Delegate Moon is suggesting is whether it would go to committee if the bills don't conform. It would go to 3 members of the Senate, 3 members of the House. But if it were to conform, that it would pass through without that step.
Yes, I appreciate that, and certainly don't have. Oh well, I think if it's entirely conforming, then that would be the best path.
Got it. Okay. Well, that'll at least be a small bit for us to think about over the coming week. Judge Morrissey, since you came sort of midstream in the conversation, is there anything you wanted to add?
Other than I appreciate this committee's hard work in looking at this. It's obviously hugely important to us and to all the judges and commissioners and magistrates. And happy Valentine's Day to everyone. Thank you, guys.
Great. All right. Are there any committee members that have any additional questions, thoughts, comments before we let our friends from the judiciary depart?
Can I add happy pitchers and catchers reporting day as well?
Awesome. All right. Well, thank you very much. I think, at least for the moment, we have the information we need, and we will be back on this bill next week. Thank you so much.
Thank you all very much.
Thank you all.
All right, colleagues, we are going to move over to House Bill 249. This was a departmental bill from the state police, and it regards DNA collection processes. And Chris, do we have MSP with us here?
I'm here. This is Dan Cass, the director of State Police Forensic Sciences Division.
Great. So
Catherine Kelly with Maryland State Police are on as well, sir.
Okay, excellent. So if you want to just give us a quick refresh on why you requested this bill, that would be helpful. And I see that you are also requesting amendment. If you want to comment on what you seek to change from what was introduced. And whoever would like to speak, you can take it away.
Yes, sir. I'm happy to do that. Happy Valentine's Day to all the subcommittee members from the top. The bill clarifies the accountability for collection for the DNA samples. It imposes a monetary penalty for qualifying individuals who refuse to provide a sample. Requires refusals to be referred to the state's attorney's office. Repeals language that uses the term arraignment and replaces it with appropriate language in accordance to Maryland rules, and establishes an expungement process for samples that are not tested. We found since the original bill passed in 15 years ago that we have some issues, and those clarifications are necessary for us to do our job effectively and not have samples that are in limbo as they are currently. That when the Maryland Correction Administrators Association took a look at our bill, they wanted some clarification to make sure that the safety of detainees and the safety of their officers were paid attention to in greater focus. So the amendments do just that. There are refusals from detainees for fingerprints, for even personal identification. So and DNA sampling. So we wanted to make sure that the correctional officers were considered to have done their duty if they made an attempt, and if the attempt failed to collect the DNA sample, that the refusal would be then sent to the state attorney's office. That just protects those folks from, without a court order, failing to do what would be in the law. We're happy to answer any questions the subcommittee has, and look forward to a favorable consideration of our bill with amendments.
Delegate Cardin, and then Grammer.
Thank you. Thank you very much, Mr. Chair. So 2 quick questions, or I hope quick. I'm trying to stop saying quick, Delegate Embry. The first is, it says, this is, I guess, on page 6, paragraph, or line 15, or paragraph starting on line 15, destroyed or expunged, that they should be destroyed or expunged. Shouldn't it be destroyed and expunged? That would be question number 1. And question number 2 is, if the person who's required to take the sample fails to take it, is the person who, would the person who doesn't give a sample also violate the section and be grounds to fine him up to $10,000 for not giving a sample?
Sir, we believe that the amendments that we're offering clarify that the correctional officer or person that's responsibility to collect the data, the DNA sample, are not subject to the penalty.
And in regards to your first question, I would actually agree with you that it should be an and.
Okay, so Mr. Chair, at the appropriate time, I'll make the amendment to change or to and in line 17 on page 6. That would be number 1. Number 2 is, I'm saying, just make sure I'm clear. So if the appropriate officer fails to take the sample, they're not subject, per the amendments, they're not going to be subject to any kind of.
No, sir, the amendment reads that if they attempt to make the DNA sample in accordance with the section, but are unable to collect the sample because the individual who's required to submit the sample refuses, they shall be deemed to have discharged the employee's duty under the section.
I understand. I'm asking the opposite. What if the person's willing to take it, but the officer who was supposed to take it either forgot or neglected to do it? Is the individual who's been charged, is that person who was supposed to get they collected from them, are they going to be subject to potential misdemeanor and a $10,000 fine?
Yeah, I would say the answer is no. I'm
The
sorry.
key word there is refusal, sir.
Yeah. Okay.
And sorry, we've got our counsel's hand up. Claire, did you want to weigh in with some clarity on any of this?
Yes, in response to Delegate Cardin's question, if you look at page 6 of the bill, line 1, it says an individual who violates this section is guilty of a misdemeanor. I'm thinking that should be changed to subsection, because then that would just relate to an individual who refuses to provide a DNA sample. And it would just clarify that, you know, if a correctional officer forgets or, you know, is unable to collect a sample, they're not going to be guilty of a misdemeanor.
Sorry, would that be in lieu of the other proposed amendment language?
No, it would be in addition. I think that was probably a bill drafting error, that it should have said subsection in the first place, because that's the way we usually do it.
Okay, so that's two small changes.
An individual who and it would be better to say an individual who violates paragraph 1 of this subsection is guilty of a misdemeanor and on conviction is subject to a fine not exceeding $10,000.
Thank you very much. All right, that's all on page 6, folks. Page 6, line 1, and then changing an or to an and, page 6, line 17. Delegate Grammer?
Thank you, Mr. Chair. So can you explain to me the portion individual may not refuse and the penalty? What is it that you cannot do now? What is it that this permits you to do? What changes here?
Sure. So we have been experiencing an increase in individuals who are required to provide a sample to just simply say, no, I'm not providing a sample. And that coincides with a lot of the discussions lately about use of force. And we've seen the numbers increase from 3 refusals in 21 to 19 and 22, and then 45 this past year in 23. And it sort of becomes a word of mouth thing where they just say, you know, word gets out that just say you refuse and they can't take it from you. So it's a growing problem that we're trying to eliminate.
Okay, thank you.
Delegate Embry?
Thank you. Just on that subject, I appreciate the problem and want to help fix it. But I'm worried that someone who's serving, you know, time for a serious felony might not care about a misdemeanor. So I just wonder, do you feel like under current law you can get a court order? Or if not, could we add that? Because I feel like that is what will ultimately have to happen if someone is truly refusing.
I mean, I don't think that hurts. I mean, the bottom line is we want the sample, but you know, the law does say that it can be taken by force, but just with the change of the environment lately, it's, you know, people are hesitant to do that. But if that was added, that would be beneficial in my mind.
Yeah, I just think that telling someone, I mean, the misdemeanor will be scheduled out, God knows when. I just don't see that as a significant factor for someone who, given what they're probably facing. But
we were trying to, you know, compromise.
Okay, thank you.
Claire, is your hand up to add additional context?
No, sorry. I'll
Not.
Okay.
So I wanted to raise for our MSP folks also, there was a favorable with no, actually it's an unfavorable, but they did propose amendment language from this Families Advocating Intelligent Registries. But the crux of their suggested text is that one only need provide a sample once. And so that they are seeking a clarification that if you've already provided a sample, you don't need to do it again. What do you make of this request?
I think that's just it's understandable why they would say that, but it's not applicable to the arrestee law since it does have an expungement clause. So you might have had your sample collected one time, it's in the process, and you get arrested again, and we say we need your second one because we don't know what's going to happen to that first one. So that's really the crux of it. I mean, for the convicted offenders, it's more reasonable, assuming that their sample is going to get collected, that you wouldn't have to do it a second time. But the arrestee aspect requires it.
Got it.
And I think there was a misread on the intent of the bill, or even the lawser about someone who has to register every time they register, that they would have to submit a new DNA sample. I believe there was a misread on that, sir.
Okay.
If I could, Mr. Chair.
Yes.
30 seconds. So just very clear, I want to make sure I heard you because I'm not a lawyer. If someone's acquitted, their DNA sample is discarded. Is that what I heard the gentleman from the MSP say?
Yes, Delegate, that is the heart of our arrestee law in Maryland. There's basically two safeguards. First, there's a trigger that requires probable cause to actually test the sample. And then if the individual is found to be not guilty, the sample is automatically expunged. And this, it just should be noted that when in 2012, our law actually went before the U.S. Supreme Court and was upheld for its constitutionality.
Okay, thank you for that background. Really appreciate it. And thank you for your indulgence, Mr. Chair.
All right. Does anyone have any additional questions or comments on the Delegate Sample Hughes? Go ahead.
I just got a quick question. Thank you, Mr. Chair, for understanding. For MSP, when you just mentioned that the sample would be expunged, is the person notified that that has occurred? Is that during the court process, or a formal letter is sent for?
Yeah, excuse me. So yeah, that is part of the process that the individual and their attorney are notified of the expungement. You will see in the bill that there is a slight change in the language trying to give a little bit more flexibility on how they're notified. And the reason for that is, when this was created back 15 years ago, it specified letters were sent, and what we've experienced is that the vast majority of the letters we send come back to us, so we want just a little bit more flexibility on how we notify them, but they absolutely are notified.
Okay, so that, yeah, I see it's on page 7, I believe.
Yes.
Line 7. Okay, and then just one last question for you. Is there a certain amount of time that you have to expunge the sample, like within 30 days or 60 days, anything like that?
I do believe there's something in the regulations again about the specific time frame, but I can't quote it. So, but that, yes, it is expedited as much as possible.
Okay, thank you.
Delegate Embry.
Thank you. I'm sorry. And I know we've spoken about this, and I raised this in the hearing, but the language now, so it used to require that the sample couldn't be tested until arraignment, and now the new language would allow it to be tested immediately, because if the person's arrested, there's probable cause. So at the point of arrest, the sample can be tested. And I just worry because arrest warrants can be requested by civilians. It doesn't have to be law enforcement requesting warrants. And I worry that the point of arrest is maybe too far back. And I wonder if could live with an indictment or see a criminal information filing instead of arraignment, just because of the possibility of warrants that are, again, a judge, right, they have been issued, but it may be, it hasn't really been reviewed and investigated by law enforcement.
I feel like it is getting that check. It's not just, somebody's arrested. It actually has to go through a process. Yes, it might be happening at the time, of the initial arrest, but I feel like it is getting a legitimate check to make sure it's not an unfounded arrest or unreasonable arrest. And, I think it's, I think it's reasonable. And also this is something that should at least be considered, is that there's a lot of talk throughout the country about rapid DNA testing within booking systems, within booking centers. And right now, we are not able to do that. And I'm not saying we should or shouldn't be, but just that is a consideration in a national trend that, allowing it, requiring it to go to an actual courtroom does hinder the possibility of that ever being allowed. So I'm just throwing that out there.
No, I share I understand the concern. I just worry that because an arrest warrant has not, that stage, there has been no preliminary hearing. So there's not been a probable cause hearing. I understand a commissioner could have deemed probable cause, but that could be just based on what someone comes in and, writes down. Anyway, I hear you. I just wanted to raise that.
Yeah, no,
but,
I appreciate that. I mean, I'll be the first one to admit I'm not a lawyer, but this is what our lawyers advised.
I appreciate it. Thank you.
Delegate Cardin.
Thank you. Just to Delegate Embry's point, I had a case where a gentleman got into a fight with his significant other. He got into a car, she videotaped it. He left because she was screaming and yelling at him and made allegations. The police came, they wound up arresting him. I have hours of video of him being both arrested and then taken in to the police, to be processed. And when we got before trial, but when we got to the trial date, I showed them the video. They realized that it was the woman who was making these allegations who was actually the one who had assaulted him. And in the end, she wound up being the one who was charged. He would have been charged as well. But I guess there are many scenarios where somebody is arrested, and in the interim, they find out, we either made a mistake or it's the wrong person, and I would see that why the arraignment issue, I mean, I understand why you guys are concerned about the arraignment, but the arraignment seems to be, or the first appearance in court would be might be the appropriate time. If it's not the arraignment, if that's the problem, it would be the first appearance in court. Therefore, there would be some vetting that would be done as opposed to simply just arresting the person. I'm just putting that out there. Like this doesn't do violence to my conscience, but you're going to have a lot of mistakes, and there's going to be a lot of spending money on these expungements and these notices of destruction. And that could be an unintended cost. I'm just putting that out there.
Yeah, I appreciate your comment. I just think we've got to, you referenced the expungements, and that's really, that's in there to make sure that if something, should not have, been pushed forward, that it doesn't make it, all the way. So I think we do have a safeguard, already there in place.
All right. Any other further questions, comments, brainstorming people want to do before we let our MSP friends have their lunchtime? All right. Thank you. So it sounds like we have at least a couple minor tweaks to make to this. So we will bring this back next week. Thank you so much.
Thank you.
Thank you. Enjoy the rest of your day.
Okay, Delegate Bartlett, are you prepared to dive into House Bill 476 regarding forensic genealogical searches?
I am, and I also have Dayton Letch from the Center for Missing and Exploited Children. He's here to answer any questions that I might not be able to answer.
Do you want to just give us the 10-second review?
Sure.
It still doesn't look like there was any sort of organized opposition. There was one person that said they were against but didn't submit a reason
Right.
why.
Right,
Yeah,
right.
everyone else was in favor, so maybe this is a quick one.
It is. I think it can be a quick one. The bill essentially allows for this technology to be used to identify missing children or unidentified remains. It has been very helpful technology in other states, and it has been very helpful in identifying folks from who's been, missing for 30 years. Unfortunately, they were found deceased, but it does aid in at least giving their loved ones some level of closure. There is one little monkey wrench, not even a monkey wrench, just an amendment. I've talked to Senator Sidnor, who is the cross-file on this bill, and in his hearing, in the JPR hearing, there was a question with respect to, could we use this as opposed to just children, use it for anyone who is missing or anyone who where we're trying to identify their remains. I don't have a problem with that amendment, and I wanted to bring it to the subcommittee as well and let you all know that that is what came out of JPR, to include that amendment so that it would apply to everyone and not just children.
I'm sorry, Delegate. So just to clarify, this bill has moved in the Senate now out of JPR.
No, let me take that back. I'll tell you in 1 second. I don't know that it's moved. I know that they had their hearing, and at the hearing, the question came up as to whether or not we could apply this technology to all individuals as opposed to just children. So I will tell you the status of the Senate in just 1 second.
It was heard on Friday, Mr. Chair and Madam Vice Chair.
Thank you. So no, they have not voted on it yet, but that is the amendment that is being offered in the Senate, and that's what came out of their hearing.
And just so we're talking in plain English now about this bill, the bill as introduced would allow, if you have the dead remains of a child, to test that against 23andMe in order to figure out who that person is. But
yes,
now we're saying the remains of any unidentified person, we would, regardless of age, we would allow to test against these databases.
that is the crux of it. Yes, with the amendment.
Huh. Any members have any questions, comments?
Well, in all fairness, let me tell you why the chair is saying what he's saying, because we heard this bill and it was controversial in the sense of you're going to different layers of individuals. So you're going to, basically the police will be allowed to use other layers of generations of individuals to, and there are strict guidelines, but to identify a person. At that time, we were using it to identify individuals who were perpetrators or who could possibly be perpetrators or who could be accused. This language simply says that what we want to do is be very narrow, and that this technology can be used in situations where someone is deceased or someone is missing. the door that opens is, again, that, you know, it is a form, it is 23andMe, and there are other people listed there. The data, I mean, the evidence obtained is not to be used for accusations or pinpointing, you know, and that type of thing. And Mr. Lynch can even go even farther with that, Mr. Chair, if you, I see he put his hand up, so you might want to clarify something I said.
Mr. Chair, what the legislation is originally designed to do is to deal with the use of forensic genetic genealogy outside of the criminal investigation context, right? And this is kind of a standard that we see with other forensic services in different state statutes that create a kind of an exception for the use of that technology for missing persons and unidentified remains. We see this, for example, in the current facial recognition technology bill that is both in the Senate and the House. It makes an exception there. Utah, when they followed Maryland's lead to create a forensic genetic genealogy statute just last year, their legislation also has a carve out that says, when you're not using this in a criminal context, trying to solve a crime, you just want to know who is this person whose remains you found, that's not something that would be subject to that kind of, all the judicial review, all the other standards you need when you're trying to preserve, and protect a Fourth Amendment. When you're trying to preserve rights. And so this is like kind of outside of that criminal framework and that kind of really focused area that the Maryland statute innovated in when the bill was passed in 2021. And what we see, for example, and that was in the materials that we provided for the hearings, was that the Woodlawn Jane case that was in Woodlawn, Maryland. She was identified 45 years later, and that kind of the ironic revelation is that her identification came 2 weeks before Maryland's current forensic genealogy law became effective in 2021, and much of the law enforcement that we've spoken with in Baltimore County and other detectives view the legislation as preventing them from identifying a Woodlawn Jane in the future because of the different penalties and requirements. Senator Sidnor said that wasn't his original intention with the original legislation, and that he wanted to make sure that folks understood that law enforcement understood that you could use it for this kind of non-criminal purpose when you're trying to identify a person whose remains you found. And I think in the Senate hearing, the expansion was saying, oh, well, why aren't we using this to identify any person that we find that we don't have their information, because otherwise law enforcement may still feel like they can't use that technology for the purpose because the statute limits them to the criminal context, the perpetrator, and that narrow set of crimes. So thank you, Mr. Chair.
Thank you. I don't know, maybe I'm getting itchy on the trigger finger here, but this seems very straightforward to me. Am I missing something, anyone? So can we just straw poll this question of this possible proposed amendment of expanding the scope of the bill as introduced from identifying deceased children to just identifying deceased people?
I'm fine with it, Mr. Chair.
Does anyone object to that concept? So can I just ask our counsel, Claire, this is a very simple strikeout of the term under the age of 18 years on line 10 of page 2 of the bill. Can we just vote that amendment and move this bill? Would that be acceptable?
Sure.
Second.
Move favorable on the amendment.
All right, all in favor of removing the age restriction on the bill, raise your hand.
Aye.
Anyone opposed to this? Okay, great. So we've amended the bill.
Move favorable on the bill, Mr. Chair.
Second.
All right, all in favor of the bill as amended, say aye or raise your hand.
Aye.
Is there anyone opposed? Okay. Congratulations, Delegate Bartlett. You've
Thank you, subcommittee members.
our first
And-
bill, Gates.
Yeah.
Let's see if we can do a very quick discussion of House Bill 99. This one is sexual solicitation of a minor through child pornography. There were,
Is this the Pippi bill, Mr. Chair?
no, this is
No,
another special.
Okay, thanks. Yeah, I remember that now.
Delegate Bartlett, do you want to explain this bill to us once again?
Can you give us the number also one more time? Sorry.
House Bill 99. So this is House Bill 99, and essentially the bill will close a loophole. So we already have language. With an existing sexual soliciting of a minor in one section of the criminal law article, but we also want to make sure that we have a person, we have prohibition against a person from committing the crime of sexual solicitation of a minor with the intent to commit a violation that's listed in another section of the criminal law article. So just to, if anybody's taking notes and they want to write it down, 3-324 already says sexual solicitation of a minor. 11-207 does not identify, says sexual solicitation of a minor, but it also does not allow for an individual who is standing in for the minor, such as a undercover officer who may be posing as a minor. So we just want to close that loophole so that there will not be, there's not that technicality to say, well, I wasn't soliciting a minor because this undercover officer is, of age. I was, and therefore not be charged under that section. So it's another tool in the toolbox for state's attorneys when faced with this type of crime and that type of circumstance. And some of the testimony actually goes towards a state's attorney who actually had that circumstance. And so we just want to make sure that we are doing nothing to make it easier to solicit our young children for purposes of, making them vulnerable to submitting any types of pictures or acts that they are not intending to give to an adult. And that obviously, as we've learned in our committee, that may come up later and be used for blackmail purposes. So that is the essence of the bill. And I have Lisa Jordan here from MCASA if you all have any need for clarification.
So just again, on the basics, it's a crime if someone solicits a minor, and if it's actually the police doing a sting soliciting pornography, if we don't pass this bill, what are the current charges available in that scenario for the person being hit by an undercover cop?
And I'm going to do my best to answer that. And I'd ask if Lisa Jordan could clarify. I'd appreciate it. But currently we do have the, what was it? What did I say? I'm sorry. I'm looking at so many screens here. 1 second here. Top. They already have 3-324 available. But under the section of, so we already have that available. However, we need also 11-207, which is the production or distribution of child pornography, to be added so that under that area where it doesn't say or a person, you know, posing as a minor. It doesn't have that information with respect to production or distribution of child pornography. So we need to make sure that we're clear that where there is an individual who's soliciting a minor or law enforcement officer, that we're also talking about the production or distribution of child pornography to the list of crimes.
Sorry, I see Lisa Jordan's hand up. Go ahead.
Thank you, Mr. Chair. Thank you, Madam Vice Chair, for the bill. I believe Delegate Moon, the answer to your question is there is no way for us to charge when you have a sting operation where the police officer is requesting the child pornography. That's exactly why Delegate Bartlett's bill is needed, right? Is that if a child is solicited, then the child pornography bill applies, but currently 3-324 does not apply. And we're just about to lose a lot of information about people reaching out to children because of the end-to-end encryption that's going into effect. So we're going to lose a lot of information and the ability to prosecute those cases. In the unlikely event that a perpetrator were charged with both things, so there was something that happened where they charged both under the child porn and under 324 as amended by Delegate Bartlett's bill, then they would merge. So you wouldn't have a situation where both charges would lie for the same conduct. So we could not, for example, have someone who solicited a 12-year-old and is charged under 11207 and then also charged under 3324. Those would merge, so they would not have two charges there. What this bill does is it says if it's a law enforcement officer who solicited the child, right now we can't do anything. Delegate Bartlett's bill would fix that, and it's really badly needed because of the technological changes.
And sorry, just so I understand the practical use of the bill, it's probably not the case that it makes good investigations that may have already happened. It's probably that it opens a new line of the undercover sting. Does that make sense? That the officers aren't currently going to try this type of trick because it's not going to yield them something jailable. But if we pass this law, they will now be able to use this in their sting operations. Does that sound?
So what's happening now is that if we're able to get the perpetrator to say, hey, I think you're a 13-year-old child, you're an officer, and will you come and have sex with me? That can be prosecuted because that's already part of sexual solicitation of a minor. But the first step is often not, will you have sex with me, but will you send me a picture of your naked body? And that's what we can't prosecute right now. So that's what Delegate Bartlett's bill fixes, is it lets us get in earlier on those cases. We can't go retroactive for sure. So this is only cases going forward.
Delegate Hardin.
Thank you, Mr. Chair. I've got both 3324 in front of me and 11207. Sorry, I actually did some homework. I'm sorry. I am trying to figure out so you want to be able to set up stings for for officers to be able to see if somebody's inducing, causing, soliciting child pornography.
Yes.
Versus just soliciting a minor for, I guess, sexual activity, right?
Yes.
So
exactly.
Right now you can use, it's covered to have an undercover person pose and try and capture somebody in a sexual solicitation of a minor. But we can't, as this is what Delegate Moon was just asking, but we can't have a police officer pose to try and get somebody to knowingly promote, advertise, solicit, distribute, possess, intent to distribute anything that would be considered child pornography. It wouldn't be getting the person to provide sexual acts. It would be to get them to do what is defined as pornography, which is not a sexual act. Is that my understanding?
Right. And look at, when you look at, I see you've got the code there, and you look
Yeah.
at 11-207,
Yep.
it says or a minor. And then it doesn't have that language that's in 3-324.
Mhm.
You see the comparison there?
Yep.
Okay, so that's the key. And one, you can have the, you could have, a law enforcement officer, posing as a minor. And the other, we don't have it because it stops at, this can't be a minor. I don't have it in front of me. I have it in front of me, but I can't reach it right now. So the point is that we've got to have that language that says that that law enforcement officer posing as a minor is the same. We're trying to capture those same folks, maybe even different folks, that are doing this online to get child pornography, which is under 11-207.
Yeah, it just says at the bottom, it says, at the bottom of number 5, A5, it says, abuse or sexual conduct of or with a minor. So that's the issue.
That's the issue.
Okay. All right.
Yep.
Got it.
Mm-hmm. And never apologize for doing homework. That's always a good thing. Better discussion.
A+ for Delegate Card and Vice Chair Barth.
Anyone have any additional questions, comments, or anything about this bill?
Can we move this today, Mr. Chair?
Yeah, exactly. I'd be happy to vote for it today.
That's sort of what I'm hanging out here. Does anyone have any, well, so it sounds like we're on the road to moving this thing. Does anyone
Move
have?
favorable.
Second.
Okay. And I don't think there are any amendments. It's clean. All right, all in favor of, sorry, House Bill 99, an aye or a hand?
Aye.
Hand.
Any opposition? All right, friends, we'll be back with a few bills next week. And when we clear those, we'll add a new stack on top. So see you next Wednesday.
Thank you.
Bye.
Bye-bye.
Thank you.